Hello, everyone, and welcome to Lavender Link, the National LGBT Bar Association's Corporate Counsel Practice webinar series. My name is Marissa Wiley. I'm a partner at Nixon Peabody LLP and a member of the Corporate Counsel Webinar Committee, which is tasked with putting on the Lavender Link series. Today's presentation is entitled Bankruptcy 101, what every in-house lawyer should know as we continue to weather the economic fallout of COVID-19. The session will be led by Jeff Tarkington. I'm joining Jeff now. Jeff is a partner at the Washington, D.C. office of Womble Bond Dickinson, U.S. LLP. Jeff has over 35 years of experience representing creditors, landlords, trustees, and equity holders in commercial bankruptcy cases, fraudulent conveyance litigation, and preference lawsuits. Jeff will be joined by Wendy Walker, who is going to be joining us right now. Wendy Walker is, hi Jeff, that's okay. Wendy Walker is Associate General Counsel and Head of Bankruptcy and Workouts for the commercial banking arm of JP Morgan Chase Bank. Prior to joining JP Morgan, Wendy was a restructuring partner at the New York office of Morgan Lewis. Following the presentation, we will have a Q&A session. Please submit any questions you may have in the Q&A box of the Zoom conference, which should be at the bottom of your screen, at any time during the program. I will monitor the submissions and we will address the questions at the end. With that, I will pass the microphone to Jeff and Wendy. Jeff?
Thanks, Marissa. It's a pleasure to join all of you today. A good afternoon for those on the East Coast. Good morning for everyone else in the country. What we plan to do today is just to provide a brief overview of bankruptcy issues from the non-debtor point of view, creditors, asset purchasers, preference, fraudulent conveyance defendants, and at a very high level, starting with just talking about the types of bankruptcy filings that you may encounter. First, there's Chapter 7. Chapter 7 is the liquidation chapter of the Bankruptcy Code. Chapter 7 is always a liquidation proceeding where a trustee is appointed to liquidate non-exempt assets and to use the proceeds to pay creditors. Also to pursue fraudulent conveyances, preferences, whatever assets can be brought into the bankruptcy estate to pay creditors. Once a petition is filed, all of a company's operations stop. The doors are locked. The company surrenders its property to a trustee, or in cases where there's a secured creditor, where the secured creditor gets relief from stay and forecloses on the collateral. The most important takeaway for creditors in a Chapter 7 case is to file a proof of claim, because if you don't file a proof of claim, you won't be entitled to any sort of distribution, even if the debtor identifies you as a creditor and does not contest your claim. You'll get a notice of bankruptcy filing. Usually in sizable Chapter 11 cases, the notice will say, don't file a proof of claim at this time. Sometimes it will. So you need to file a claim timely. And if the notice says, don't file a proof of claim at this time, then keep your eye out for subsequent notices, because typically there'll be a notice that goes out at a later time and it'll set the bar date. As far as your proof of claim form, the form is on the bankruptcy court's website, and typically you also will receive one in the mail from the court if you've been identified as a creditor. It's an relatively easy form to fill out, but you need to be complete and accurate. You need to attach some form of documentation to the proof of claim form to establish your claim. You don't want to attach 2-3 inches of paper, but sufficient to establish your claim, and if you're a secured creditor, copies of the UCCs or whatever to establish that you are properly perfected. It's well worth the effort to file a claim, although in many cases there might be a zero distribution to creditors. There are cases where distributions are sizable, and it's not uncommon to have a 100% pay case, even with interest. It can take a long time before you get paid. Trustees have, in Chapter 11 or Chapter 7 cases, have to sell the assets, file a final report before they can make distributions. But and that may not happen for 5 years, might not happen for 15 years, but still, it is worth filing the claim and just letting it sit. The one thing to look out for in all of these cases will be claims objections. In sizable cases, you'll see that the claim objection may have 100, 200 claims objected to simultaneously. You want to be on the lookout for that. Usually those are, if your claim is objected to, typically those are resolved without a need to file a response. Oftentimes the objection is because your claim does not exactly match up with what the trustee's books and records indicate you're owed. Sometimes litigation is necessary, a response is necessary, but very often that can be resolved without the need to resort to litigation. The second type of bankruptcy is Chapter 11, and that's the reorganization chapter of the Bankruptcy Code. It's designed for corporations, partnerships, LLCs, and individuals to reorganize their assets while continuing to operate their businesses. Usually individuals won't file Chapter 11s if they can qualify for Chapter 13, but if they don't fit, if they can't qualify because their debts are too high, then you'll see individuals file Chapter 11. In a Chapter 11, no trustee is initially appointed. Rather, the debtor is a debtor in possession and continues to operate its business in the ordinary course of business. Although with many aspects subject to bankruptcy court approval. But the trustees are only appointed in cases where there's typically malfeasance or something along those lines. In a Chapter 11 case, the debtor will file a Chapter 11 plan of reorganization that creditors will get to vote on. In many larger cases, you'll see that the purpose of the Chapter 11 really will be to liquidate the assets, and that's what we're seeing in large part right now, especially with retailers. They are, or many of them are going out of business, but they're filing Chapter 11s to do it in an organized fashion, to have liquidation sales, and eventually, their cases will they may get a plan confirmed, but it'll be a liquidation plan. Also, what you often see in larger bankruptcy cases will be the establishment of a liquidation trust, especially under a Chapter 11 plan, where the assets or the proceeds of sale will be transferred to a liquidation trust. Once all of the assets have been liquidated, then the trustee of the trust will make payments to creditors. Another form of Chapter 11 that we're seeing more and more of are structured dismissals, which often also involve the sale of all of the company's assets and the distribution of the sale proceeds without the cost and delay of even having a Chapter 11 plan. The third major type of bankruptcy is Chapter 13. These are wage earner cases. where only for individual debtors where the debts are not over about $1 million. There again, a creditor must file a proof of claim to receive a distribution. We don't plan to talk about Chapter 13 cases today, but feel free to ask questions later. There are other chapters of the bankruptcy code that we rarely encounter. Chapter 9, municipality bankruptcies. Chapter 12 are farmer bankruptcies, and Chapter 15 are cross-border cases. And yes,
sorry to interrupt you. I just thought I'd jump in there with some, a few statistics. So in the commercial and investment banking arms of JP Morgan, we see many more Chapter 11s than 7s. We rarely see trustees appointed. As Jeff said, they are appointed for fraud or gross mismanagement that has to be proven. So it doesn't happen very often. Trustees are also, they could be authorized to operate the business, but typically they are not. And as Jeff mentioned, they simply liquidate the business, which means, of course, that going concern value is lost. At JP Morgan in the commercial bank, as of the end of August, we had, not really a big surprise, but more than a dozen already major Chapter 11s than we had in all of 2019. There's no surprise as to the reason for that. And as Jeff alluded to, it's there's a big concentration of Chapter 11 cases occurring with retailers and also oil and gas, because when everybody stopped driving in the early spring, oil prices went negative for a couple of days there in April. So.
Yeah, if we'd only had storage facilities for a few 100 million gallons of oil, we could have stockpiled it for a few days and then made a killing, but that didn't happen. Well, we turn next to just how bankruptcies are commenced. There are two ways. One's a voluntary bankruptcy. Voluntary bankruptcies have to be approved by the in accordance with the company's organizational documents. Typically, that'll be a board of directors resolution. It is worth pointing out that if you don't have proper authorization, then bankruptcy courts will dismiss the bankruptcy case, and that comes up right now more often in with respect to commercial real property bankruptcies. Commercial real property borrowers typically are required by their lenders to include in their organizational documents provisions that make filing bankruptcy more difficult, requiring unanimous consent of all members, which can include one that is an independent director that is required by the lenders. If you don't have if you don't have the proper consent, then typically you will see the bankruptcy courts dismiss the cases. Not always, but that is the routine. There's the other, in addition to voluntary filings, there are involuntary filings, and there the bankruptcy code has a provision that enables creditors to file an involuntary petition against debtors. If the debtor has more than 12 creditors, you've got to have at least 3 creditors join in the filing of the petition. An involuntary can be useful where you think the debtor is fraudulently conveying property, or where other creditors are executing on judgments and you want to stop them from doing that. However, filing an involuntary can be risky. There is a high threshold to file. It's a low dollar amount. It's about $16,000 that has to be owed to the creditors that are filing the petition. But the debts cannot be contingent as to liability or amount or subject to a bona fide dispute. And if they are, that's the basis for the court to dismiss the involuntary petition and to charge the petitioning creditors not only with the attorney's fees incurred by the debtor in getting the case dismissed, but whatever damages the debtor incurred because of that involuntary petition. Because of that, you need to be quite careful before filing an involuntary.
And I would just say that it's something that we very rarely do at JP Morgan for the reasons that Jeff mentioned, but also because for senior secured lenders, you would have to go right out of the box and declare that you're partially at least undersecured, which is something that we certainly don't really want to do, and it's not worth taking the risks that Jeff identified.
Yeah. And if you do, and I had a case of several years ago where a client wanted very much to file the involuntary, and we did, and the court upheld it, but only after discovery and a full day hearing, where of course you are, at the end of the hearing, you're quite anxious because you don't know how the judge is going to rule. So that's always something to be very careful about before you go down that path, but it is a legitimate path. So once the bankruptcy petition is filed, then in a Chapter 11 case, typically the company continues to operate its business as a debtor in possession. Existing management typically remains in control of the debtor unless the court orders otherwise, and a trustee is only appointed on rare occasion. The major benefit often from the filing of the bankruptcy petition is what's called the automatic stay, and I think Wendy, you were going to talk about that. Oh, I can't hear you.
I just wanted to emphasize the automatic stay. It prevents creditors from taking any action post-filing to recover on account of pre-bankruptcy debts. It's an issue for large institutions like JP Morgan because we have many, many automated processes. We send out bank statements, we send out credit card bills, we send out mortgage statements, et cetera. And all that process is automated. And so for large institutions, it's something that they have to be very, very careful of to either stop those statements from going out or take some other action to prevent violations from the automatic stay, because they're punishable by sanction, and you can be held in contempt of court. And so it's, for folks that don't practice in this area, again, it's something to be very wary of. Don't call, don't write, don't email, don't fax, don't contact a debtor if your purpose post-filing is to collect on account of a pre-bankruptcy claim.
And from the debtor perspective, oftentimes the automatic stay is the most beneficial aspect of filing a bankruptcy. It stops a foreclosure. Oftentimes you'll see bankruptcies filed on the morning of a foreclosure sale. It stops any lawsuits from proceeding, and it can even operate in a way that is like filing an appeal without having to post a bond. Some of you who are as old as I may recall the Texaco bankruptcy case, where Texaco got a very large, I think it was about a $12 billion judgment rendered against it that rendered it unable to continue to operate business because of the risk of having that judgment executed on. It filed bankruptcy, and it appealed, filed bankruptcy, and was able to negotiate a resolution of that claim. It still paid, I think, a couple of $1 billion, but a whole lot less than the amount of the judgment, and that the bankruptcy gave it that breathing space that enabled it to continue to operate and to negotiate that outcome. The I'd like to turn next to some of the important questions creditors ask, such as, how am I going to get paid? Or what if I want to do business post-petition with the debtor, will I get paid? And third, I don't want to do business with the debtor, but the debtor's claiming I have to keep doing business with it because I'm party to a contract. Well, let's turn first to how to get paid. The starting point, as I mentioned earlier, is to file a proof of claim. But if you're a general unsecured creditor, you're at the bottom of the heap, and you won't get paid until likely, long after a plan has been confirmed and distributions are made to unsecureds, or, in a Chapter 7, once the trustee has liquidated all the assets, paid all the senior creditors, and then has money left over to pay you. It's basically a waterfall for unsecured creditors. But there are some ways that some creditors can get paid earlier than others, and one of which is, of course, if you've got a secured claim. And Wendy, do you want to talk about secured claims and dip lending and all of that?
Sure thing. Just on the proof of claim point, I also want to emphasize that there are very few mistakes in life that can't be fixed, but missing a bar date for filing a proof of claim is one of them. So that's one, if you're not regularly practicing in this space, to really pay attention to. Because it's very difficult to establish excusable neglect. And in big institutions, sometimes notices of bankruptcy go floating around for long enough that you could miss a bar date. So it's important to keep an eye on that ball. With respect to secured creditors, one thing we want to emphasize, I think, for secured creditors is the importance of being secured. If you are notified, or if you learn that a debtor has started to blow through its financial covenants, it's in distress, a workout needs to happen, one thing to do right away is to do a collateral review if you are a secured creditor, to make sure that your liens and claims are bona fide. Some of you may be familiar with the GM case. It's a pretty sore point for us at JP Morgan, but our liens on GM were inadvertently released prior to filing, and that caused about a decade's worth of litigation. So that's very important. The reason to be, some of the benefits that you get by being a fully secured creditor in bankruptcy are protection. So you're prevented by the automatic stay from foreclosing on your collateral, but you're entitled to protection against diminution in the value of your claim as of the petition date. That usually takes the form of interest and fees. And when the debtor is unable to provide adequate protection, that's a basis for relief from the automatic stay to foreclose on your collateral. But more often than not, the debtor has a vested interest in being able to use its cash collateral. It may need post-petition debtor in possession financing, and therefore it's motivated, highly motivated, to work out a deal with its senior secured creditor so that the creditor is getting the adequate protection it's entitled to, and the debtor is entering into bankruptcy with the ability to access its cash and to borrow if that's part of the package, so that it isn't presented with a big litigation fight on day one and the possibility of not being able to access its cash to pay critical bills if it's attempting to reorganize, such as utilities and landlords and employees. There are then additional protections and benefits that secured creditors are able to negotiate if they do provide post-petition financing. And this is separate from the credit decision about whether to do that, but on the legal side of things, those protections can include, as I said, a consensual deal on adequate protection, interest and fees, The debtor typically stipulates to the validity, extent, and priority of the secured creditors' liens and claims. It typically also contains a provision that allows your proof of claim so that you don't have to worry about the bar date. It typically includes also a waiver of the debtor's right to surcharge the collateral for the expenses associated with liquidating that collateral on the secured creditor's behalf. Also typically provides a carve out from those liens and claims, a negotiated amount, so that the debtor and committee professionals can be paid. And restrictions on the use of proceeds. So for example, you can't use the money I lend you to come back and sue me. And there are many more. DIP orders have, expanded over the years from, I think, originally 10 or 15 pages to now sometimes upwards of 100 pages. But one of the key things that they provide also, though, is that post-petition financing is entitled to an administrative priority, meaning it has to be paid in full in cash in order to exit a bankruptcy. So that's a key. That is a key protection for secured creditors, and really allows you to. And debtors wouldn't appreciate me saying this, but it allows you to, in many respects, control the case. So I'm going to stop there, Jeff, and see if you have anything to add on that.
No, I think you addressed that pretty well. So, but let me ask you the question. So, because of that, you are your consent is necessary for the confirmation of the Chapter 11, essentially.
That's exactly right. And so, one thing we've seen in some of the recent retail cases, although many of them are turning into liquidations, as you mentioned, we're also seeing upfront that debtors don't just want a post-petition loan. They also want to try and lock in, if they can, their ability to exit Chapter 11, because I don't think it should come as a surprise to almost anybody on the phone. Chapter 11 is expensive. The professional fees can reach into the tens or hundreds of millions of dollars in large cases. And although you do have a breathing space from some of your creditors, you still have to keep paying your regular bills if you want to keep operating and reorganize. And so what we're seeing on the DIP side of things in retail cases at JP Morgan is that debtors want post-petition financing, but they also want, subject to the business performance, and again, putting the credit decisions to one side, they also want to try and lock in exit financing before they ever file. And so there are a variety of ways to do that. Many want to enter into a restructuring support agreement with at least a term sheet on the exit financing terms. And it's all subject to the debtor's performance through the Chapter 11 and their budget. But they are trying to, as part of the price for the protections that they give to the DIP lender, trying to lock in their ability to get out unless catastrophe strikes.
And probably it's a good time to mention one thing, which is the Unsecured Creditors Committee, which typically 5 to 7 of the largest creditors are asked by the United States Trustee's Office to serve on a committee of unsecured creditors to represent the interest of the unsecured creditors. And the Bankruptcy Code enables them to hire counsel, professionals, all at the estate's expense, as Wendy mentioned a few minutes ago, and to basically represent the unsecured creditor interest in that bankruptcy. And Wendy, what is it like? Why don't you discuss what it's like to deal with an unsecured creditors committee as the DIP lender?
Well, I mentioned earlier that in a typical DIP order, you get the debtor to waive its objections to the validity, extent, or priority of DIP lender claims, typically pre-petition and post-petition, obviously. But what that means is that the creditors committee is the person, the entity that we end up negotiating with throughout the case. They have usually a certain period of time, the challenge period it's called, to contest pre-petition secured creditor claims. They often seek extensions. Occasionally the DIP order will give them automatic standing to bring those claims. More often than not, they have to seek standing, and they will do that within the challenge, and they have to do that within the challenge period. And, you know, as for what it's like to deal with creditors committees, it's challenging occasionally, because where you really don't have any, where you really don't believe that you have any legitimate challenges to your claims, I would say that at JP Morgan, we sometimes feel as if we're held out there for a while, with the threat of those kinds of claims being out there, you know, usually for longer than we want. And it can be frustrating, but it's part of the dance.
Much of bankruptcy is negotiation, and each party wants to hold as much leverage as possible for as long as possible in the negotiations.
Yeah.
And very often, you know, almost everything in a bankruptcy case is negotiated, and you know, you hold that leverage as long as you can.
That's right. And, you know, I guess in fairness to creditors committees, since so many of the large Chapter 11s in the last downturn and in this one are turning into liquidations or pretty quick sales, their argument would be, you know, you're selling at the bottom of the market. And if you sell at the bottom of the market, your liens and claims are legitimate, but I'm going to end up with pennies. And if you could just finance this a little longer until things turn around, and then sell it, I would do better. That would be the unsecured creditor argument. And I, you know, of course, appreciate it, but only up to a point.
Yeah, although I would think that you know, typically the lender will benefit from an orderly liquidation of the assets, so that a going out of business sale over a number of months will benefit a lender much more than just shutting the doors and having the inventory sold in some other manner.
Well, absolutely. I mean, and COVID has thrown so many of these things up in the air. We were involved in the Modell's bankruptcy, and the cash collateral hearing took place on the Friday before the tri-state area, New York, New Jersey, and Connecticut, shut down. And Modell's was not essential. They couldn't reopen their stores to run the GOBs until, I think, May or June. Landlords, the debtor negotiated a pause in the case so that the landlords weren't getting paid, and, you know, obviously we're not happy about it, and you could understand why. The liquidators couldn't go in and run the GOBs because the stores were closed. They couldn't go in and get the inventory out of the stores to move it to a location that might be open because the employees weren't allowed to go in because of the COVID shutdown. And, you know, you're right. Once we ultimately had an orderly liquidation in Modell's, the senior lenders both got out. I don't know how the unsecured creditors are going to do, obviously.
Yeah. So, well, let's move on. You know, another question creditors often ask is, you know, I would like to continue to do business with the debtor post-petition, but what's the risk? Am I going to get paid? And the answer is you should. And, you know, claims that arise in the ordinary course of the debtor's post-petition operations are administrative claims that have priority in payment over pre-petition claims. And the debtor is obligated to pay its post-petition obligations on a timely basis. And if it fails to, then that's a basis to convert the case. And, you know, one party we haven't really discussed is the U.S. Trustee's Office, but it's an arm of the Department of Justice that oversees bankruptcy operations, and typically it's not particularly active in Chapter 11 cases. It leaves that to unsecured creditors. But in smaller cases, there will not be a committee, and you will see the U.S. Trustee's Office get involved. And those are often the cases that you see the debtor fail to pay post-petition obligations currently. And when that happens, the trustee's office will step in, usually pretty quickly, trying to convert the case to a Chapter 7, but it can be a few months. And you know, during that lag, you don't get paid. and you may not get paid unless at the end, when there's a liquidation, there's enough money to pay priority claims. And in those cases, oftentimes there'll be nothing left for unsecured creditors. Some of the actions you can take as a creditor doing business with a debtor, you can put the debtor on COD basis. Oftentimes you'll see creditors continue to do business with their debtor customers on COD, or ask for prepayment, or monitor the case carefully. The debtor has to file monthly operating reports that disclose its income and operations. You can take a look at those and get a sense of how whether the debtor is going to be able to continue in operation. The other thing is to look at the whatever financing is being provided post petition by the lender, and when is that going to terminate? And if it's going to terminate, say, 4 months after bankruptcy, 6 months after bankruptcy, at that point, if the debtor can't get an extension of the financing, then it's going to cease operations. So, other ways to get ahead of the pack, if you've delivered goods, if you sell goods to a debtor and you've delivered them 20 days before bankruptcy, you have the right to seek an administrative expense priority for that. You need to file a motion, though, to establish your claim. You also may be able to get designated as a critical vendor for the debtor, which can result in you getting paid almost in full, close to the beginning of the case, for your pre-petition claim. And there, again, oftentimes in larger cases where debtors have creditors that they need to continue to do business with, but where the creditor is refusing to do business, refusing to sell, and not obligated pursuant to a long-term contract to continue to sell, then debtors will get court authorization to pay what they call critical vendors. And the factors the debtors typically look at in determining who's going to be a critical vendor include, most importantly, the impact the debtor would incur if the creditor refused to continue to provide goods or services to the debtor, and whether the debtor could reasonably obtain those goods and services elsewhere. Usually if you end up, and this is all subject to negotiation typically with the debtor, but if you end up being designated as a critical vendor, you'll end up signing an agreement, and usually that agreement provides that that you will continue to do business with the debtor on the same terms that you conducted business pre-petition, and usually there's a discount involved, so that if you're owed $1 million pre-petition, you may have to discount your claim 10 or 20%. But the good thing is that then you get paid. You do continue to do business with the debtor, which hopefully will have the sufficient resources to continue to operate. And so if you can get on the critical vendor list, that often is a real benefit. Another way of getting paid early is to sell your claim. And especially in larger cases, there are companies that will focus on a specific case and buy claims of creditors, sometimes for strategic purposes, but usually just more of an investment. They watch the cases sufficiently carefully. They know what they can offer and where they can make a profit, because they know the company is likely to reorganize successfully and what the ultimate payout to unsecured creditors is going to be. The sale agreements usually contain indemnification provisions that mean that even if you sell your claim, you may end up funding the claims purchaser's attorney's fees if there's an objection to that claim. And the other thing to keep in mind is almost always, if you hold on to your claim, you don't sell it, you will get more ultimately, a better distribution than if you sell the claim. So the issue is really whether you want to sell the claim, go ahead and get money for it now, or wait. So what can go wrong after you filed your claim? Well, one, claims objections that we mentioned earlier. Be on the lookout. Again, it can be a thick document, but if you, and typically claims objections are going to be resolved without the need to file a response. But if you do need to file a response, you have to do it timely. Otherwise, the claim will be disallowed. So you need to be vigilant. So bankruptcy can be painful for creditors simply because they aren't getting paid for the goods they sold or the services they provided. But it can get a lot worse. You can get sued for a preference or a fraudulent conveyance. The preferences are typically any payments made to creditors within 90 days prior to bankruptcy, unless you're an insider, in which case it's a 2-year look-back period. But any payments made to creditors within 90 days may be subject to recovery as a preference. The test is, was the transfer made for the benefit of a creditor on account of an antecedent debt while the debtor was insolvent within 90 days? It enabled the creditor to receive more than it would have received in a Chapter 7 liquidation. And if the debtor is insolvent, which is going to be presumed by the bankruptcy code, then pretty much any sort of payment, any payment is going to fit into that category. So then you turn to what your defenses are. And the defenses are going to be whether the payment was in exchange for a contemporaneous exchange for new value. Was the payment made COD? If so, it's not going to be a preference. Another defense is where the payment was made in the ordinary course of business. And there, you look at both the ordinary course of business between the debtor and the creditor over a 1 or 2 year prior period, as well as the industry standard. And if say over a 2-year course of business, the debtor typically paid its debts to you, paid the invoices every 30-day terms and kept within the 30-day terms, then you may have a good defense. If the debtor was late or early, say ended up paying 20 days, not 30, or paid 40 days, not 30, then it likely is going to be a payment outside of the ordinary course of business. There's also another good defense is if you're a fully secured creditor, and then you don't have to worry. But where you're undersecured, what sorts of issues do you see, Wendy?
Terrible issues. Your claim, will be valued as of the petition date. If the value of the collateral does not exceed the amount of the debt, then you are undersecured, and you can typically, figure out how undersecured you are. And so it is possible to be a secured creditor, but nevertheless have the debtor or the committee able to recover a preference on account of the unsecured portion. That's the theory behind preferences are that a debtor in the 90 days prior to a bankruptcy filing is, just paying the creditors that are the most aggressive and that it absolutely has to pay in order to avoid bankruptcy and stay in business. And so the preference provisions of the bankruptcy code are designed to bring all that back in and then distribute it out arguably more fairly, pro rata to the unsecured creditors that file proofs of claim that are upheld in the bankruptcy case. So that's the theory. My business colleagues never really appreciate the theory of equality of distribution, but that is the theory. And it can happen, as I said, even if you're a secured creditor.
Yeah. And if you are the subject of a preference, usually the trustee will send out, or the trustee or the debtor's financial advisors are going to send you a letter telling you, please pay, you received $20,000 before bankruptcy within 90 days. We are going to file a lawsuit against you, but we're going to give you the opportunity to pay 80% of that, and we will release our claim against you. And your response is, you look carefully at your books and records, and actually one defense is if you continue to supply goods or services to the debtor after you got payment, that can be a defense. So in response, you identify all of your defenses to the trustee. Again, in bankruptcy, so much is subject to negotiation, and almost always preferences are going to be negotiated, and either it'll be as a result of the demand letter that the trustee sent, or if you fail to negotiate a resolution at that point, it'll be after they file a lawsuit. Sometimes you'll end up with discovery. In large preference cases, you can end up spending large amounts of money on attorneys and experts who will testify that the payments were made or were not made in the ordinary course of business. So, but these cases rarely are ever litigated. Again, they typically end up with a consensual resolution.
I think it's another good reason to file a proof of claim also, because as you said, Jeff, a lot of it is negotiation. If you have a valid proof of claim on file, there can be a little push-pull there with a potential preference.
Yeah. And the resolution may be the waiving your proof of claim, right, in return for their waiving their claim against you. So, you're right. And I think we have just a couple of minutes left. Let me touch on fraudulent conveyances. There are two types of fraudulent conveyance under bankruptcy law: intentional fraud and constructive fraud. Intentional is where the debtor, more often than not, an individual rather than a company, transfers funds, hides assets, transfers funds to a shell company in the islands. Individuals give their house to their kids. That's intentional. Constructive is where there's a transfer for less than adequate consideration while insolvent. And there, an example would be selling a $1 million house to the kids for $500,000, something like that. The bankruptcy code lets trustees, debtors in possession, pursue these claims for it's a 2-year statute of limitations, but they also can access state fraudulent conveyance laws, which oftentimes can go back even further, 4 years, or even if some discovery, some states even let you go back further, depending on when you discover the fraud. And again, fraudulent conveyance claims, especially constructive fraudulent conveyance claims, typically are negotiated. Intentional fraud, there's usually more involved there, and those are cases that courts often end up having to try. And I'm not sure, Marissa, if we have a couple more minutes. If so, I'll touch on executory contracts.
Yeah, I think you should take a couple more minutes.
Okay. If the bankruptcy code authorizes debtors to assume, reject, or assign unexpired leases and executory contracts. And Executory contracts are contracts where performance obligations are still due on from both parties to the contract. You know, most contracts are going to fall into this category. And if you are a non-debtor party to an executory contract with a debtor, you're going to have to keep performing your obligations under that contract, either until it's assumed or rejected, or you get some sort of relief from the bankruptcy court. And you can end up in a very unhappy situation where you're obligated to continue to perform, and in some instances, you're not getting, the debtor is not continuing to perform its obligations under the contract. Here, typically a debtor has until plan confirmation to decide whether to assume or reject a contract. Leases of real property are different. There's a much shorter period of time for that. Keep in mind, some contracts can only be assumed with the consent of the non-debtor party. For example, personal service contracts, government contracts, and in some circuits, intellectual property licenses can't be assumed unless the non-debtor party consents. But most contracts can be assumed by a debtor if the debtor, to assume a contract, the debtor has to cure all pre-petition defaults and also to pay, including payment defaults. So you do have that benefit in that, especially if you have pre-petition claims under a contract, that they have to be paid in full unless you consent otherwise, if the debtor is going to assume that contract going forward. The one thing to watch out for, the key thing, is that oftentimes debtors, especially in larger cases, are going to file these massive motions with hundreds of pages of exhibits that identify each and every contract they plan to assume and the cure amount necessary to bring that contract current. And if you fail to notice or respond or oppose if that cure amount is incorrect, then the court will grant the motion, and you're going to be limited to whatever amount was in that motion, identified in that motion as the amount to cure your default. So even if you have a proof of claim on file saying you're owed $100,000 pre-petition on a contract, if the debtor says you're only owed $1,000 and the court grants a motion permitting the assumption of that contract on those terms, they can pay you $1,000, and that's all you're going to get for your pre-petition claim on that contract. So, and then contracts can be rejected either with court approval or where the time period for assumption has expired, then the contract may terminate automatically. So I think those are probably the major points we wanted to go over today. We're going to talk briefly about asset sales, but I think we only have about 5 minutes left for the program. So Marissa, if I'll turn it over to you for questions.
Yes, thank you, Jeff and Wendy, so much for that informative presentation. I'm sure it'll be very helpful for folks who are still trying to figure out what to do in this economic climate. So if you have any questions, please add them to the Q&A box at the bottom of your screen, and I'll start with this one. If a company is struggling, what are some actions it should take prior to filing for bankruptcy?
Well, of course, from where I sit at JP Morgan, what I would say they ought to do is to develop a business plan, a budget, 13-week cash flow, and work with their senior lenders on that in order to be able to at least use their cash collateral without any interruptions going into the bankruptcy, borrow money if they need to, et cetera. But I think that that's one of the most important things that a debtor needs to do. Because if it doesn't have access to cash or funding that it needs, it's not going to be able to pay employees, and you can't have employees come to work if you can't pay them. And you can see, where that would lead pretty quickly, unfortunately.
And I think a number of lenders will advise customers in that situation to find a financial advisor, to work with them to get the budgets together. And having a legitimate financial advisor, and there are plenty out there, working with the company can provide, I think, a lot of comfort for the lender to be able to work with the company and have comfort in its projections.
Yeah, and it seems to me that doing that, taking that step, would also help lead the way in maybe a pre-bankruptcy workout, that if you do have to fall back on the bankruptcy option, you can kind of have your bankruptcy hopefully completely planned out before you even file that petition, which is, I know, a lot of debtors like to do.
Yeah, it's really important point. I mean, bankruptcy stays a lot of litigation and attempts to collect pre-bankruptcy debts, as we discussed, but it doesn't create money. And it really is expensive. And so going in with a plan to get out is really important. Years ago, in cases like Texaco, which Jeff mentioned, the average Chapter 11, large Chapter 11, would last around 18 months to 2 years or so, maybe sometimes longer. Now, debtors really try, and their advisors really try to help them get in and out as fast as they can.
Marissa, we can't hear you.
So, yes, thank you. I thought I clicked on mute, but I must have missed. Speaking of advisors, when should a company contact a bankruptcy lawyer?
Probably about the time they contacted an advisor, or perhaps even earlier. It helps to contact a bankruptcy lawyer as soon as you think you may be encountering difficulties, because worst case is you have a short consultation, while on the other hand, and there may be some simple options that are out there that you're not aware of that a bankruptcy lawyer can identify. Because if you wait too late, the house can come crashing in, and you can lose control over the reorganization process.
Yeah, I would add, it's really important for a board of directors to be well advised, hopefully by their general counsel, if not by their outside counsel, on their duties as directors. They have a duty of care and a duty of loyalty. The duty of loyalty is designed to prevent self-dealing, but the duty of care is really a duty that requires them to look at the business with their eyes wide open. And they have a duty to, maximize the value of the assets and company for shareholders. But as the debts get to be bigger than the assets, that the list of stakeholders to which they owe a duty expands to include creditors. And so, once that starts to happen, that's really when they need to, as Jeff said, get some good advice about all of their options, because that is what their duty requires them to do, is examine all of their options.
Right. I think it's a really hard thing to do, to look at the reality and say, okay, I think we need to think about the big scary bankruptcy word. But it really can be less intimidating. I'm sure that's why we call it restructuring. But the sooner you are proactive, the more options you have, and the less likely you are to fall in pitfalls, which are many, and that's true for debtors and creditors.
Yeah.
We have another question, which is, on the topic of fraud, is the reaction to discovering it met particularly better or worse given the circumstances of the person/entity? Especially given the circumstances of COVID-19, how does this affect negotiations?
As in intentional fraud? I'm not sure a response to that question, but yeah, I think it really is going to depend on the type of fraud, whether it and the magnitude of the fraud. You know, if we're talking a Bernie Madoff level of fraud, then you know, that is highly disruptive to any sort of the conduct of a business. If you know, if so I think it really is in large part going to be a level, an issue of magnitude. And Wendy, do you have?
I think we all acknowledge that desperate times can lead to desperate measures sometimes. But as Jeff said, you know, and we are seeing some of that here and there, not a lot, but yeah, the way that COVID-19 has upended the entire world, including the financial world, is going to lead some of these schemes, if they're out there, to be exposed just because of the fluctuations. And, you know, I think it doesn't happen often, or it hasn't happened often yet, but when it does happen, it really, you know, this is really an understatement, but it limits the ability of the debtor to reorganize once that happens. You have to completely clean house. You have to fess up to what's happened. You have to cooperate with investigators and law enforcement. And, you know, the U.S. trustee, the arm of the Department of Justice, will come in and say that a trustee has to be appointed. And so your ability to reorganize after something like that, even if you've gotten rid of the bad actors, is going to be severely limited.
Right. But I think it will be a question of fact to a certain extent. I mean, fraud is fraud. If it gets to fraud, you're going to be in a hard spot. Yeah. But if intentional versus unintentional, you know, misinformed versus silly, I think that probably will have an effect on negotiations. But I agree with you. At the end of the day, Wendy, you're already in a bad spot, which is why you need advice early, and it needs to be quality advice.
Right.
All right. Well, we've reached the end of today's Lavender Link presentation. Thank you, Jeff and Wendy, so much. And thank you all for joining us. We hope you see you next time.
Thank you.
Thank you.
Bye.
Bye.